you don't already have a bingo sheet,
Is this a game of chance, and is there a cost to enter? Because
yes,
AG and
We don't have to answer any of his questions.
I'm happy to. And the prizes are an ice scraper. No, it's got a price tag on it. It has not been used, I promise. That's for the practical, because it will snow. The other prize will be mega stuffed Oreos. The laissez faire out there who want to get crazy and make friends. And then for those of you that need to make it through the day, I've got a 5-hour energy. That's another prize. All right. I'm Greg Ferbrache. This is Craig Barlow. And it's bingo, criminal procedure bingo. So you have 24 squares. Go ahead and fill those squares in. And you can use any number 1 through 40, 9.5, 15.5, 21A, 21.7B, and 29A. All those numbers will get called, so you should probably use one of those weird offsetting numbers there. As you're filling out your card, and everybody have a card? Bingo card?
there is a one number.
This train will be going by the time.
All right. So I want to make sure, we're going to be talking about the rules and some aspects of it. And if you have any anecdotal experience or have any questions on the rule themselves, this is intended to be as interactive as you want it to be, and hopefully it will be interactive, so we don't have to. Repeat like the 12th game of bingo. That was expensive, because I only have 3 prizes. Feel free to offer your experiences with these rules, because as you well know, we work with these rules all the time. We get judges' rulings. We are at times creative with these rules, and the opportunity to learn from each other's experiences, I think, is invaluable. So this is one of the goals that we had today, was to not only for you to go through the rules with us, but for us to learn from you and your experiences.
The most useful part of the rules of criminal procedure is the table of contents. It's good to know what's in there and also what is not, and there's only 40 of them, so having some idea that certain subjects are covered in the rules is probably the first lesson in using them effectively.
So if you have a device, I suggest pulling up the table of contents on your device. That'll help you scroll through. Ultimately, with this game, we'll tell you what the rule is. We'll let you guess, but we'll tell you what the rule is. So if you don't know the rules, don't worry. That can get called on. Ultimately, we want everybody to win or have a chance at bingo, a chance to win, which is not criminal because you didn't pay. Anyway, is everybody ready? Got their bingo sheets? Your first round of bingo sheets?
We're ready.
All right. Should we make them raise their hand if they know the answer, or just shout it out?
I think raising the hand might be
We'll start politely.
a bit more calm.
All right. And these are randomly selected by our paralegal Tegan Troutner. Tegan. So if there's any complaints about the randomness of this, put a lot of research into the randomness. All right. Okay, what rule speaks regarding arraignment? What rule speaks about arraignment?
Brian, table comments. 10.
10, rule 10. All right.
Arraignment follows the returning of indictment. Does anyone need me to use the microphone?
We're good.
Following the return of an indictment or following a bind over. Those of you who practice criminal law probably know that. Those of you who don't, in Utah, at least, your first appearance in a criminal court is called an initial appearance or a first appearance or showing up. No plea is entered. You're assigned a lawyer, and then you, depending on the variations in the 8 judicial districts, you will have a series of hearings until the preliminary hearing is set, or you may have one set immediately.
Okay?
Rule 10.
Rule 10. We got 10 marked, if you put it down.
Yeah.
You didn't screw up on the first one enough to 10. Do you need an English sheet, Mike? Here, let me get you another one. I don't want you to miss out on the
So, Craig,
Let's go.
question.
Yes.
So, when is a motion for bill of particulars allowed prior to arraignment?
Never.
Really?
Yes.
Oh,
That's coming out later, however.
okay.
What's the harm if you're denied your arraignment? Is there any?
Well, there's no harm because I'm not. You always will have a chance to enter a plea. It's really the when that's critical. I'm not sure. Are you thinking of a case where someone missed?
I have a case where they're claiming they were denied their arraignment, but I can't think of any harm.
Well,
Other than they didn't get notice of the charges, which they did.
Yeah, because you do the reading, and then you deny, and then you request your prelim.
Yeah, I don't. For most of these, most of these there is no sanction for non-compliance. In fact, most of the rules tend to say if you don't comply with this when you're supposed to, then you can fix it later or at some other time.
What about, is there a time frame for arraignment? Like if he's being held in custody and he's never arraigned, couldn't he assert a problem then? I mean, once he's been convicted,
The rule does not state a time, but it's like with most rules and most rules of criminal procedure, within a reasonable amount of time. I have a case right now that was filed in 2013. We finished the second day of a preliminary hearing. That was a year ago in December. We do not yet have a third day of the preliminary hearing. It's now on a petition for an extraordinary writ in a separate court. And this defendant has been in jail since July of 2013, and he's not yet been arraigned. And I know I'm not worried about it.
So, paragraph C does state that any defect or irregularity in or want or absence of any proceeding provided for by statute or these rules prior to arraignment shall be specifically and expressly objected to before a plea of guilty. So, before a plea of guilty is entered, are the same as waived. So I guess it's anticipated you would have to cure that, you have to ask for the opportunity to cure that prior to your entry of plea. Or okay. All right, everybody got 10? Can you write 10 down and mark it off? You didn't take advantage? No.
Oh,
Yeah, that's nice. Oh, you need a pen? All right, everybody have pens as well? I bought a pack of pens this morning. It's going to be one of the prizes, but then I need bingo question. A rule that tells us about indictments, informations, and the bill of particulars.
Oh, Aaron Riley.
Rule 5.
Rule 5. Everybody mark Rule 5, number 5. Oops.
No. It's
Oh, did I get it wrong?
Rule 4.
Oh, sorry. My table of contents says Rule 5 is
It's been randomly selected. I'm sorry that you feel that we've slided the prime numbers, odd numbers, or whatever.
So Rule 4 is titled Prosecution of Public Offenses. It's really informations and what they set forth. We do have indictments in Utah. One issues about every 12 or 14 years. I don't know. They're rare.
Elizabeth Smart.
Elizabeth Smart, I think, was the last one, which then didn't go anywhere. So, the bill of particulars is a request. Basically, it's the civil equivalent of a request for more definite statement of the charges. It can only be filed after arraignment, which means after the bind over. You often will get them from defense attorneys right after you file the charges. Well, for instance, gee, here's an example right now from a prominent Salt Lake City law firm, Snow Christensen and Martineau, where I used to practice, where they basically have asked for bill of particulars in the defense of former Attorney General Mark Shurtleff, and they have not yet even scheduled a preliminary hearing. So I'll have to call my friend Rick Van Wagner and suggest you read Rule 4.
Well, they're actually having a hearing on it as well, aren't they?
Yeah, they're even having a hearing, but the rule is pretty clear. So.
All right, anything on Rule 4? No? All right.
I got a question.
Yeah.
Coming from the matter, why don't they use the grand jury more in Utah? If you guys don't know, it's fine, but I was just curious.
The grand jury in Utah, that would be a whole separate small section. It is not like a standard grand jury in the federal system, where there are many other states where you have a constantly seated and active grand jury. It actually, grand jury in Utah is convened by a group of district judges only for certain kinds of cases. And Utah has a very robust jurisprudential history about preliminary hearings and their multiple uses. They're not only to establish probable cause, but they also are recognized by the courts as a necessary and important discovery mechanism, which you don't get with grand juries and indictments. And defense attorneys obviously love preliminary hearings, far prefer them to grand jury proceedings, which are sealed. So that's why there's been talk of trying to modify the rules and use grand juries more, but I don't see that happening for many, many years.
We are trying to make inroads on that discovery purpose.
I know.
And I think we've had, if I remember correctly, we've had some success.
Well, in the famous words of the boatman in Man for All Seasons, them that makes the rules don't row a boat. For those of us who are practicing, my experience is discovery is still, all the defense attorney has to say is, I'd like to go in that more, Your Honor, even though it is far afield of the scope of direct, and you don't really see where it's going at all. I have not heard a judge yet say, well, this is only a probable cause hearing, and discovery can be accomplished some other way. It's always, oh, go ahead, take a couple hours. So,
I guess what I would suggest is if that's pushed too hard, you can always say that tends to be a corollary, but you don't have a right to discovery.
well, yes, though.
To use it for that.
Right, though I think that's how it is used extensively, and again, my experience has been very few judges are going to enthusiastically cut off cross-examination. So.
All right, does everybody have a bingo sheet? No? Okay. Bingo sheet, and the numbers we've called so far are 10 and 4. Yeah, well, yeah, that's true. All right, that's your penalty for being late. Bingo sheets, there's some on the tables. Okay. And it's, there's 24 squares to fill out, 1 through 40, as well as 15A, no, 15.5, 9.5, 21A, 27A and B, 29A. All right? Okay, and I'll refrain from affirming the rule until we actually get confirmation of the rule. So we've actually called 10 and 4. All right. Next. Bingo question. What rule states that in a child abuse and sexual offense against children case, the child's oral statement is admissible upon motion and for video?
15.5.
Let's see.
That was correct.
Let's see. 15.5. Everybody put 15.5 on the bingo? Yeah. All right. Rule 15.5. I think the most important, really the most important factors, because the rule is so detailed and nuanced with all the many factors that you have to go through, is that you have a child younger than 14 and you have a statement that is recorded prior to the filing of the information. If you have those two things and you want to proceed without the defendant present or to use the child's prior statement, then it's you go through these factors. I didn't want to spend a lot of time on those factors, because I think that's another training as well. Does anybody have any questions on 15.5? We can certainly go into questions that you might have. No?
And just if you're gonna do it, read the rule,
Yeah.
follow it scrupulously.
Yeah,
The child has to be available for cross-examination.
that is correct. And whether or not the child is present in the courtroom there's really two parts to the rule. One is whether or not a prior oral statement by the child can be admissible at court with the child present and the defendant present. And then the second part of the rule really is whether or not the child has to be in the courtroom. Can you remove the child into a separate location and record them? As well as, does the defendant have to be in that courtroom or that other room with the child and or visible to the child? There's a myriad of factors that you go through with that. But I think understanding that really the first two questions you have, the major question is your child younger than 14 years of age? If that's the case and you're dealing with a child abuse case, it's a definite pretrial motion. This is not a day of rule. Any questions or anything? No? All right. This rule requires a high level of expertise. If you do or think you have a case that deals with this rule, I suggest getting a hold of Craig, Chris Knowlton, any of our attorneys on ICAC, our special prosecution unit as well works with this rule quite a bit. It's definitely detailed in yours. All right, everybody got their 15.5 marked? Next question. Errors and defects.
30.
Ringers there. All right, let's see. Rule 30. All right, you can mark it. Confirm.
And basically, Rule 30 says that unless there is an effect on the substantial right of a party, and what that really means is the substantial right of the defendant. Almost none of these rules provide remedies, relief, or assistance for the state. Almost all of them relate to rights, remedies, and options available to defendants. Almost anything can be corrected at an appropriate time. If not, you just do it over either by a formal motion for non-pro-tonque action, or the court will just enter relief as necessary.
Okay, anyone? All right, next question. That was Rule 30. The judge in your case gets too sick to continue the trial. What rule will you go to in order to get another judge assigned?
29. Oh, sorry.
That's all right.
29. Blurting is okay.
All right, let's see. Rule 29. All right, Rule 29. In order...
You're in the 29A, right?
What's that?
29A. This is disability. 29A is which is a matter of
Disqualification.
Yeah, the certifying judge, so if your judge is unable to proceed, the certifying judge has to be familiar with the record of the trial, and then that certifying judge may proceed and finish the trial. The rule indicates that the judge may grant a new trial. I think with the recent case that Sandy Johnson did, in which she had a case where the judge called a mistrial and then left out of the courtroom, and I guess Sandy didn't protest enough, and they called double jeopardy on that.
Well, it wasn't because she didn't protest enough. She protested.
Well, they made reference to that, and she could have done more, I think, is what.
Well, but they're saying, yeah, but she was caught off guard. She didn't know this was going to happen.
Right.
And actually, a lot of the fault goes with the judge on this. Well, I know the fault goes with the judge on this one. It's just that now, as Sandy put it to me, now she knows that if the judge gets upset about something and decides to declare a mistrial without warning anybody, you need to, it's the job of the prosecutor to stop the judge from doing it.
Which in her case may have included running into chambers.
And having a large box of tissues.
So, yeah.
Wait, I mean, I had a, not exactly similar, but quite unusual circumstance when I was prosecuting years ago. And we were arguing about some motions, and all of a sudden the judge got up and left. And we were just hanging out in the courtroom, waiting, and apparently the judge got up and left and got in his car and drove away and never came back.
Ever for the rest of his career?
Yep.
What did you do?
Luckily, we haven't impaneled the jury yet.
Okay.
We're just doing some pre-trial motion, and so, we just start over with a new judge, but sometimes you can't control the judge.
Was
You
this
don't know
the,
what he's gonna do.
was this the trial with the guy who kept having sex with the dog? Because I would have left that.
So I think the lesson here is that although the rule indicates that the judge may grant a new trial, you have to be very careful about stipulating or agreeing to that, because of the fact that if the jury's been impaneled, the defendant has a lot of rights, and they're very, the rights are very clear and well supported in case law. One of the intermediate remedies, I think, is just delaying the trial or stopping the trial, sending the jurors home for the evening or a day or two until you can get a second judge or a certifying judge familiar with the record. Obviously, if you're in district court, the judge can listen to the record and review the record so that they're caught up. But be very careful about this part of the rule where it says you can just have a new trial. I think you should be very careful about that, and that should be a last resort with objections. I don't know that you should ever stipulate to a new trial once the jurors have been called. But I think that's just my practical point.
Well, it's okay if the defense consents to it, right? That's the problem.
Well, yeah.
Yeah, it's if the defense consents to it, but you better make sure that it's on the record.
Knowingly, voluntarily, intelligently, all that stuff, and
Well, it doesn't necessarily have to be that. It just has to be consent. And so counsel says, okay, we're fine with that. So if counsel moves for this trial, right, the defense, he's consented to a mistrial.
Maybe, but then you're just going to end up in post-conviction, where the defendant's going to say, well, my counsel was ineffective because he agreed to the mistrial.
You can't stop everything.
So I stand by my point. Don't stipulate it. Don't agree to it. Just argue it, and then whatever happens, happens.
Well, but there was a case in which the defense wanted one and he disagreed with it. It's because there wasn't enough record of that got.
Oh, geez.
Yeah, so
All right.
I'm just saying.
All right, don't argue too much. But
Just write them out.
just write them out. Got me with you on that one. All right. All right, that's rule 29. Everybody got theirs marked? All right. Bingo question. Dismissal of cases without trial with substantial cause and furtherance of justice. Anyone?
25?
Anyone?
25.
We have a 25. Anybody? Anyone? Bueller? All right, let's see. Rule 25. It is confirmed. If court, I think the important thing about 25 is that it's pretty subjective for the most part by the judge, and so there's arguments to be had. However, the rule is pretty clear that if the court finds unconstitutional delay or statute of limitations violation, it's a bar to further prosecution. So the court may use this rule to dismiss the case, and you can refile. But if the court orders or rules that you committed unconstitutional delay, or that there's a statute of limitation issue, obviously the statute of limitation is pretty objective. You know, what's the date of offense? What is today done? Had you not filed, there's no tolling, things like that. Unconstitutional delays is more of a court finding, and I think there's some argument to be had and some findings to be had. But in either of those circumstances, you are barred from further prosecution. So you want not concede that element. All right, anybody have any issues on this one or experiences that we're going to talk about getting your cases? Bingo question. Search warrants.
40.
Correctamundo. Rule 14. Search warrants provides definitions, grounds for search warrant, conditions precedent, and protections. Next slide. Oh, there should be one. There's
two questions.
Yeah, there's two questions, Craig.
Oh, there. Okay, so the next one. Oh, okay. Go ahead.
Yeah, some rules we have double questions on. This is so interesting.
Yeah, that one ready.
Thank you. All right, bingo question. What rule, and I haven't been keeping track of the numbers, so I have no idea what's been, as long as somebody is. We're all on your honesty card today here. Let's see. What rule states that any plea agreements between the defendant and the prosecutor shall be approved or rejected by the court? Do we have an 11? All right, rule 11. 2-7. Mark that on your bingo card. The one thing it does not say, but it needs to say, is that if you do not advise the defendant of their immigration consequences, you may see the defendant again because they need to be advised.
But we do have a problem with this because lots of times in post-conviction they come back around and they're trying to say the court had to advise them of this. And really, we like the court to advise them and we want it with the agreements, but it's when counsel is committed ineffective assistance of counsel by not advising them that you're really in trouble.
Mm-hmm.
The judge is not required to advise them. It's just that if the judge does advise them, then it's very clear and it's on the record and there's no question later.
And
Which
they
is-
can show prejudice.
Yes, but
and
which-
maybe not even do.
But which is why if you're a prosecutor and you see that there has not been an on-the-record inquiry of the defendant and his counsel, and the court doesn't do it itself, you probably need to, as a minister of justice, step in and say, Your Honor, I think we may have a BIA question here, and I think it's important that the court advise the defendant that his immigration status may be implicated by the entry of this plea. Help most defense counsel, I don't think, will purposely make a mistake under this rule. Though, again, for those of you who do not practice criminal law, you probably know that plea agreements generally are submitted to the judge, and one of the paragraphs is, this will not be binding on the trial court, and he may or she may reject or accept the plea, so there's a little bit of uncertainty. A Rule 11 agreement allows you to go into the court before you actually enter the plea and make sure that the court is willing to accept the plea that is entered. In that case, the court is then bound by its acceptance of your plea agreement negotiations.
Anybody have any questions on how to do that, perhaps, or if you've done it and it's done a stop on you?
You know, this is one reason why you should always use the court form
Right.
on your Rule 11. Don't just use whatever the defense hands to you, and make sure that's in there, because that's the number one thing that will help you. But if you know that there might be some immigration issues, I think it's probably a good idea to state on the record, you know, Your Honor, we just want to make it clear that, you know, there are immigration, maybe ask counsel before you go in there. If you guys talk about this, do you know? And just get that on the record, because if it's on the record that they know and they've talked about it, it's just going to be really hard for them to come back later.
Absolutely. And I think for those of you that practice in 3rd District, the plea form, the court form, I think that's an excellent best practice, is always using the court form, because, you know, it's not a Word document, it hasn't been manipulated, you know exactly what's on it. That court form does have the language of immigration consequences. It's when you get out of Salt Lake City and in some of the other districts that they may not even have a court form. As a practice now, I've got a 3rd District court form that I carry with me to all other districts. You probably don't want to hear
It
this,
should be on the court's website, though. That's the thing.
Yeah, but-
There is a standardized
form. Yeah, in Beaver, and they don't even have court forms. You
I
need to have
know.
oral.
No, you're right, that's.
Oral
that's
2 to 30 on
right.
sexual exploitation of minor. You can just look at the county attorney and ask him if this is going to hold up. He's like, yeah, that's how it goes. You're like, all right.
Or some defense attorney is using a form that's 10 years old and he just keeps copying it in his office. He
Yeah.
never updated it.
Yeah. So definitely form is the best. All right. Any other anything else? No. All right. Next question. What rule states that the defendant in a justice court setting may appeal for a trial de novo in district court?
38.
Do we have a 38? No.
Oh, wait, no.
27A.
Oh, sorry.
Yes, it is.
Wow.
All right?
Does anyone in this room give a crap about?
I use it on my own side.
Yeah.
Because the link doesn't show up on the de novo appeal if you get a ticket in Draper and they gotta go all the way.
Oh, yeah.
It's good, it works.
I didn't mean personally.
Finally we got something good out of it.
After the trial de novo, if you get the speeding ticket?
If you get found guilty in the justice court, which you will, just file the de novo appeal, you get a pretrial, and the Draper City prosecutor's got to come out to the court. So I've been dismissed twice. One was from Draper City out there.
So moving on.
Spinning right now.
So that's
That was worth the price of admission right there.
Anybody else want to make a personal disclosure?
The man's just exercising his rights.
This is
And his
Greg,
rules.
not Jerry Springer. So let's just
Oh.
Yeah, the 2 bites of the apple rule. And if you've prosecuted in misdemeanor court, you know how fun this would be.
Yeah, you do everything twice.
All right, bingo question. This rule states that the prosecutor, defense counsel, or defendant if not represented shall receive full disclosure of the pre-sentence report unless doing so would jeopardize the life or safety of third parties.
16.
Let's go with 18, but I'm not confirming it yet. Don't mark it.
Neither confirmed nor denied.
And a 19? All right, let's see. Anyone else want to guess?
Are they allowed to use cell phones to get the answer?
Yeah, devices.
Bingo's the game we're playing, not this shadow.
Yeah, that's, Utah courts type no. Fire up your devices.
21 days.
21A or 22?
21A.
21A. 22.
21A.
Choose the left.
22. Choose the left.
All right, so 21 days, pre-sentence investigative report and restitution. There's a lot of different aspects of this rule, but restitution may be determined at a later date with agreement of the defendant and the prosecutor. And the restitution hearing should be set if the amount is disputed. What happens quite a bit is when you're doing your sentence or you get to the sentencing stage, restitution has yet to be determined or the restitution amount is in dispute. And what is also important in this is that although the pre-sentence report is prepared by the probation agent, they are not in charge of the restitution amount. They compile it by communicating with the victim, but they do not determine the restitution amount. So the court is not bound to that. And if you have any dispute with that, then you should certainly let that be known, especially on behalf of the victim, whoever that might be. The court will usually indicate what time frame, like, well, you need to have it in 45 days, you need to have it in 90 days. In the rule, it does not indicate, but I do think it has to be a reasonable time, and certainly I think it's on you to communicate to the court that 45 days, at the 40th day, it's not sufficient amount of time. I don't think you're barred from asking for that continuance.
There is I think there's a statute, I'm trying to remember the timing it does, but I think it requires that restitution be determined within a year.
I believe it's a year. Yeah.
And we have a case right now where the prosecution made the request within the year for the amount, but the whole thing was argued about and decided after the year was up. So we're having this big argument about whether that's good enough. So you probably want to just be on this, because if you just get it in and get it decided before the year or get stuff on the record, it could save some angst.
So what you're saying is that not only is your request, but your determination needs to be made within that year period?
Because it says shall be ordered.
Yeah, it should be.
Yeah.
And we're arguing that
That's
that's not, we don't know the answer to that yet, but my point is it would be nice if this weren't even an argument, to tell the truth.
Yeah.
As a practical matter, unless restitution is very straightforward, for instance, in child sex abuse cases or even sexual abuse cases, very often the primary restitution is that the defendant will pay for counseling, therapy, and possibly medical expenses. That can be pretty straightforward, and that amount is not yet known, but that is the defendant is ordered to pay whatever is determined, John.
But if they're sent to prison, then the Board of Pardons can deal with that after the statutory year. The board can actually even kick it back to the district court.
That's
if
also
there,
true.
If there needs to be a hearing on that. The problem here was this guy wasn't sent to prison.
Right.
So the
But-
board didn't have
But
jurisdiction.
sometimes that can be done at sentencing.
Yes.
In financial crimes, as a practical matter, no judge and all of the attorneys in the court do not want to hear the entry or a sentence and then a 5-hour hearing while you do restitution. Much better get the sentence, determine a restitution hearing at some later date, get a special setting so you don't hold up anyone else. And the judge is prepared to both hear testimony and kind of block out a period of time.
Okay. All right, 21A. All these rules seem so simple on their face. Just reading them, which is not easy to believe. All right, next question. What rule states that multiple violations of state laws, county ordinances, or municipal ordinances arising from a single criminal episode shall be filed in court with jurisdiction over the highest possible penalty for the offense charged? 9.5. All right, any dispute with 9.5? Let's see. Oops. Sorry. Oh, where am I going? That's not.
Oh, we're
Keep going. Which way am I going?
well, you're going forward, we need to go back.
I am?
Yeah, go back.
Yeah, I'm going this way. Everybody close your eyes. Oh, geez.
And the sunshine.
Bingo!
Goodness.
And thus ended the trick. Thank you very much.
Very good, you guys. Excellent presentation. And it's short.
And it's succinct.
Everybody got that?
Is this it right here? That's it, right?
No, keep going.
9.5 is where we left off.
Keep going.
Right there. See if I can go to the next one. Yeah.
All right. I don't know what happened. 9.5.
Okay. And actually, I think it's just skipping.
What?
What?
27B, 9.5, 15.5.
We didn't do 27B.
It's 27A.
And
We did
27.
Oh, we got 2 bingos.
We didn't have 27. We didn't have
Scott, what are yours?
27B.
I think Aaron gets it.
I vote for Scott.
Scott, what do you have 27B?
No.
No.
27A.
Oh, okay, then I don't have to.
I only got 3
still vote
prizes.
for Aaron.
You want something Oreos.
All right.
Scott.
Isn't there a rule you can't be a member with no division
Scott has
and
to-
win?
Yeah, that is the
All right,
rule.
so for those of you that weren't here, we have a snow scraper for your window, unused, brand new.
Wow.
For the more practical sense. The Mega Stuff Oreos, little laissez-faire today, right? Little sugar high, are making friends. And if it's going really poorly for you, the 5-hour energy.
I'll go with that.
It's a long day. All right, so let's new sheets.
Don't forget your sheet.
Get to play again.
Yeah.
No, we just keep going. No, really.
We don't know that.
Start. Oh.
Oh, wait a minute.
Keep going.
Yeah, let's just keep going.
Let's keep going.
Yeah.
I only have 3 prizes, all right? Just so you know.
Okay.
All right, so after the 3.
We're engaged, Greg. We're engaged.
All right. This is really important, especially for the AG's office, at least from my perspective, where we usually have multi-jurisdictional crime sprees or activities in multiple areas. So when you do your information, this will determine where you file your charges. It's the court that has jurisdiction over all the offenses in which it has the highest sentencing ramification, okay? And once you're in that court, it's unnecessary to sever because they have jurisdiction over all the other charges, all right? A little tidbit.
But there is a trap.
What's the trap?
Well, it's the trap that falls into, you know, when the counties or cities found these little things in. They probably want to check us but file it in justice court, and they file part of it, and then it turns out it's a felony.
Oh, yeah.
So just be aware of the cases out there. There's a statute too, Somerville.
So if you have a class B or C, it may be an issue.
If you plead to that and resolve it before it proceeds in the higher court.
Okay, so there's felony charges. And
Which sometimes people try to do.
Yeah.
They run in and.
Just don't plead to a B or a C, come on.
Wait, you're telling us? You mean?
No, sometimes-
Okay.
Now, sometimes what happens is some other jurisdiction
Yeah.
does that.
Right.
So just be kind of aware of it.
Yeah. I mean, that could happen with prostitution. And,
Probably wouldn't happen so much to us unless we don't charge this kid.
we try not to. I try.
Always got.
We get referrals. Brittany, did you have? Nope. Okay. Anyone? Anyone? Nope. All right. Moving on. Pretrial conferences.
13.
13.
Okay.
All right, we got two that say 13.
Oh, man.
13. Okay, pretrial conferences, defendant may waive his or her right to appear. From a practical sense, it usually pisses the judge off if the defendant doesn't show up, and you kind of wonder if a warrant should be issued. But the defendant may waive his right to appear. I think, in a practical sense, they should do that before the actual hearing, because the judge will want to know that he's been notified and that he's not missing. And from our sense, it's nice if they don't show up, we'll just ask for a warrant. But the defendant may waive his right.
Does the prosecution have to agree to that?
Not according to the rule. Nor does it require a judge's order. And it may waive his or her right. I think as a practical sense, it would be good on the defendant to request the judge his non-appearance.
Well, and yeah, the prosecutor may say, well, Your Honor, I noticed that the defendant's not here. I understand from counsel that he's waiving his rights. So make sure it's on the record.
Well, that's different too than if the defendant is ordered to appear.
Yes,
and he doesn't show up.
absolutely.
Well, it obviously depends on what the subject matter of the pretrial conference is about. If it's rescheduling something far in advance, or it literally is something that between the lawyers, appearance of the defendant, even if not waived, may not be super critical. If you're setting trial dates, and that's what the subject matter is, the defendant's not there, and then there's confusion, the defendant's having surgery or something else, and you don't have an explicit record, you can end up in a collateral attack somehow for ineffective assistance or just scheduling delays. So, subject matter of the pretrial conference may determine how much you care about this.
Yeah, and if you're setting a trial and the defendant doesn't show up for trial, it's harder to argue that he voluntarily did not show up so that you can proceed a trial. Because then, the defense attorney is not going to argue strenuously on behalf of him contacting his client. He's going to, in fact, try to argue to delay the new date. So it's problematic at best. All right, any other Rule 13 stuff? Anyone? All right, next question. No bingos? Exceptions.
2.
20.
Did you even know there was a rule for exceptions?
Does that mean objections?
No.
No, it means exceptions.
Exceptions to the rule.
All right.
And the rule is 20, and they're not necessary. Thus ends this rule. In the old days, you used to take exceptions to jury instructions. You could also take exceptions to rulings from the bench on motions or objections. It's really kind of an archaic.
Or exception to opposing counsel's stress.
No, you can't do that. That's umbrage. Take umbrage.
No rule on umbrage, just so you know.
But no
No
exceptions.
umbrage. All right. Maybe case law.
Just don't worry. Yeah.
All right, next question. Citation to decisions. Another compelling rule here. Anyone?
37.
37. Nobody should know this rule. All right, Rule 37, there's nothing to talk about, like citations and decisions. Make sure you do it. Now that you think
In
about
the
it,
event
now
you
you
cite a
just
decision.
do it.
Do so?
All right, any questions on this one? No? Any questions, read the rule. We're not going to spend time on it. All right. What rule provides that in order to detain any person arrested without a warrant, determination of probable cause must be given within 48 hours to continue detaining that individual? And it's trick questions, too.
Yeah, that's true. It's a court case.
Huh?
Yeah.
There's just a minute. Crap, I just read this one.
Rule 7, and it is a trick question because the rule, as stated in the book 2014 or whatever, is wrong. It's been changed to 24 hours.
Which is causing great consternation in a couple of counties where the county sheriffs now say 24 hours, the county sheriffs will no longer facilitate PC statements. And so, at least in the law enforcement area, there are a number of chiefs that are going to the local prosecutors saying, this is BS, you can't do this.
Yeah,
It's
so,
not getting them anywhere, but they're still saying.
yeah, I think this is an interesting rule because there's a lot of procedure that's involved in all this that's going on. So, and let me read this next part because that'll kind of help us with it as well. And I think there's a really important practical part to this, which is bail determination shall coincide with the recommended bail amount in the uniform fine bail schedule unless the magistrate finds substantial cause to deviate from the schedule, which is something to consider when a warrantless arrest is made and higher bail is needed. So what happens? If you have a person who has already been issued an arrest warrant, meaning that information and arrest warrant has been signed by a judge, then that arrest is by sight, right? It's the officer identifies the person, takes him into custody, books there's already an existing bail amount as ordered by the court. We're really done. Like you get your initial appearance, the person gets their initial appearance, either within a couple days by transport, or they make that bail amount and they bail out and they get a date probably a couple weeks out. So what we're talking about, this issue here, is if somebody gets booked on a probable cause arrest, meaning that the officer observed the activity, say it's a DUI or it's a domestic violence, aggravated assault, maybe even a homicide, where they are doing a probable cause arrest. They the chief, if I misstate anything, certainly you'd be the one to correct me, so please do so. But what happens is the officer, the law enforcement person, will take the person to the jail and book them in. At that time, generally, the officer will be asked to prepare a probable cause statement, just a written statement as to what the basis of the arrest is for and why they're being held in jail. Based on that probable cause statement, the magistrate will initiate or review that probable cause statement. And if he finds or she finds that meets the elements of the offense, they will issue a bail in the amount of the bail schedule. Well, the bail schedule is 5, 10, and 15. 5 for a third-degree felony, 10 for a second-degree felony, and 15 for a first-degree felony. Well, if you're dealing with a murder, a first-degree felony, 5 to life, high likelihood to flee, the person's dangerous. The court may, in their discretion, order a higher bail, but they could also just order the $15,000 without more.
And sometimes what happens as a practical matter is that, and this is going to change, there's some question about how this will change. But as a practical matter, this is usually a justice court judge in most jurisdictions reviewing this on paper, checking boxes, or in some counties, some districts hitting a computer form, and the presumption is bail schedule bailable. So you could theoretically, in fact not just theoretically, it would not be hard to have a capital murder with a bailable amount on the schedule that is presumptively bondable. So you kind of got to.
Well, it may not be the capital murder may not be a justice court.
Yeah, first degree.
In a first degree, yes.
Right. So I'm not sure this is really a prosecutor's issue so much as it is the investigator's issue. But we're telling the cops, be aware of this, because you may have a judge just going,
Yes.
not thinking about it, and then it goes to the jail, and unless the jail calls up a bail commissioner / magistrate,
Yeah.
your person may bond out and go to Timbuktu or.
Right, and so as a best practice, if you're law enforcement aid, if you're working in a strike force or you're working hand in hand with law enforcement, and there's a real compelling reason, likelihood to flee, danger to the victim, danger to the community, you don't have much time to draft up an information and probable cause statement so that you can get that higher bail. Otherwise, there's a period between when the magistrate imposes that bail, that initial bail, and the initial appearance. It is at the initial appearance where they can increase bail if necessary, or at the time, well, basically, practically, let me back up. When you file your information and your probable cause for the issuance of a higher bail, when that gets signed, then the magistrate in the jail get served that, and they're bound to the higher amount until the initial appearance. So,
And just another comment, Greg, if you are working in like the strike force where you're advising officers, it's now, there's a greater duty on the officer and the officer's associated prosecutor to make sure that Rule 7 gets met and complied with, because in the rural districts, the amendment says that the district court administrator will create a system for review according to the convenience and willingness of the judges to review.
right.
And that may be problematic. So you may have somebody, it may not be a first degree felon, it may just be a second or third, somebody you need to keep in, like it's a secure strike force and you're concerned about, literally leaving the
Well, even if it's
country.
domestic violence, like
Yeah.
the victim's out there.
You want your cops going to have to come to the prosecutor and say, how do I do this? The jail used to do it for me. They don't do it. So for a while, there's going to be a transition period that really behooves the prosecutors to be pretty dialed into what's happening in their particular areas.
Yeah, and if I understand the rule, I understand the rule right, this order or this rule change is to the judge. It's the judge who has to act within 24 hours, which
Yes.
means that if it's a nighttime arrest, the 24 hours is the next business day.
Correct.
So
I don't think it's business day.
No, it's the next day. It's the next 24-hour period.
Well, it's 24-hour period, so if it's night, then it goes to night, the next business day was 8 to 9.
No.
It's
It's
not,
not.
it's not.
It's not.
If you get arrested on Saturday, you get to see the judge on Sunday.
Oh, okay.
Yeah, and that's a
My
lot of
bad.
people were saying, well, you didn't really mean that when you made the rule change, but I'm told they really meant that when they made
Okay,
it.
yeah.
Well,
That's
They
good.
just forgot about the Supreme Court and that whole Riverside County with Los
No,
Angeles.
no, they did not forget about any of that.
Well, I'm being snippy.
Well, they got mad that people were arrested the day before Thanksgiving and then kept the
So
entire
you still,
weekend
yeah, you still
without a
get
bail
turkey.
hearing because
They
it's
got
not a
turkey
business
in jail.
day.
That's
That's
BS.
why they should do it.
Just in terms of process,
Out of jail.
Laura is the former chair of the Supreme Court Rules on Criminal Procedure, and I was drafted against my will as a member. The consideration of this stuff takes many, many, many meetings. What's interesting, and probably Ken mentioned some consternation in rural counties, there are no law enforcement members of the committee. It's all lawyers and judges. We do discuss impacts on smaller counties, rural districts, and law enforcement and judges and others. Having said that, we often hear, and this is not my way of criticism, but you often hear, well, that's going to be difficult in San Juan County, or a large, remote, lightly populated county. The response usually is they'll figure it out. You're going to have to, this is the rule. We're not going to have 4 rules: one for San Juan, one for Salt Lake, one for Rich, and one for Miller. So there tends to be a little bit of.
Although we were told, I thought pretty clearly, repeatedly, that this is not a problem.
Right, and that's we would often hear, well, this is going to be a problem in San Juan County, and then after some discussion, it was, well, no, they can figure this out. It's going to be a little inconvenient at first, but it can be done. So
The challenge, Laura, is that it's not a problem if the sheriff is willing to be a support mechanism for the other agencies. But in Tooele County, which has got some interesting political machinations in the sheriff's office, the sheriff, when this rule came out, said, well, I'm not going to mess with this. It's your own problem. And now you got police chiefs of Grantsville, an agency, 3 people, and they say, what are the rules of criminal procedure and why do they apply to us?
Well, that's fine, they can do whatever they want.
they
Not to
can.
work that out, but my point is that, you know, we had prosecutors from other counties, and no county seemed to be, none of the prosecutors seem to be having a problem. So, yeah, well, if it doesn't apply to them, I guess they can sort that
Because the
out.
prosecutors don't see the same issues that the investigators do.
So I
Again,
guess
a discussion for perhaps another day.
Yeah.
I do want to distinguish this rule from the obligation to get your information and probable cause statement for arrest filed within 48 hours pending the defendant's release, all right? That's a different obligation, it's not a rule obligation, but you do have 48 hours in which to get this filed, and that is a 48 hours, that is a business day common law. Best practice is to get it in. If you are unable to get it in within that 48 hours, you can ask for an extension of the court. The court may or may not grant that request and send it over to the jail to keep the person in for a longer period of time so you can get your reports read, your information prepared. But that's, I want to distinguish that from what this is, which is within the 24 hours. All right? Anyone? No? That's Rule 7. Bingo question. Coordination of cases pending in district court and juvenile court. Riveting rule here. Anyone? Just throw out a number.
39.
39.
Okay.
Nice work. All right, 39. If the defendant has a pending juvenile case, you have a duty to notify juvenile court with initial pleadings in district court. So if you have a young defendant in adult court and you know that there are proceedings ongoing in juvenile court, you have an obligation to notify them. The rule indicates that generally your initial pleadings from adult court are sufficient to provide notice to the juvenile court. It's a rarity, but I guess it's a rule. Anyone? Nothing to add there? Question. What rule states that jurors are allowed to submit written question to witnesses?
17.
Okay, we have a 17. Anyone?
16?
Trial.
17. All right. With the consent of the accused. It also needs approval by the court and stipulation of the parties. In writing or made orally in open court. That's to the stipulation. I guess also this is actually kind of a nuance in the rule that I don't think we deal with often, but when it does happen, it's kind of an oh shit moment, and so I thought I'd illuminate that as well, which is you can proceed to trial or complete a trial with less than your 8 jurors in a felony case. So when the judge says, you know what, half our panel showed up, we're going to go with however many we get. And I remember the first time that happened, I was like, what? You can't do that, but yeah, you can. The parties just have to agree to it, all right? So you can proceed at trial, and if you lose a juror during the trial, which in fact, I had a juror helping an older victim. She was like 87, so she tripped, and as she was falling, one of the jurors reached out and caught her, which I thought was good for the case. But so she didn't fall, but he sprained his ankle pretty poorly. He pushed through the trial, but this rule would allow you to proceed with one less juror if the parties agree. So I think that's important. It will happen to you. And now you know if you didn't already.
And of course, if you lose a juror by disqualification before verdict, i.e., one of the jurors remembers in a child sex abuse case that in response to the question, have you ever been a victim of sexual abuse as a child, they say no, and then kind of during the course of the testimony triggers their memories, and they say, oh wait, I was multiple times. That juror can be excused, and you can proceed to verdict with the remaining jurors. But on the record, of course, you make sure by probably additional questions to the remaining jurors that you do not have contamination or prejudice and that the trial can proceed even once the disclosure is made.
If that's the case, they still have to have consent of both parties.
Most of this stuff is consent of both parties, yes.
And I think the best practice here is if you have a victim, especially if your victim's 87 or your victim's from out of state, or it's a big case and you don't want to do it twice or restart it, have an alternate. It's really easy to get an alternate, have them there for the duration of the trial. It's just plain and safe. And so I think that's the best practice. It is, unfortunately, another person out of the community that has to sit through 5 days of trial. But it's better than doing it twice.
Just a little story. And of course, you don't have to agree, and the defendant doesn't have to agree either, and sometimes they're not going to agree. But I prosecuted in a little tiny county in Washington State, and we were picking jurors, and we ran out of jurors. And the judge said to the bailiff, "Go down to Albertsons and get some more jurors." And he did. He rounded up people in the store and handed them, and he said, "You're called to jury duty."
Am I going to Albertsons? Wow, that's crazy. All right. And how'd it go?
And about 5 people showed up, and we finished.
Were they really pissed or were they okay?
And I don't remember that they were. They didn't express it in court anyway.
Didn't want to, at least. All right. Bingo question. Arrest, judgment before sentencing.
23.
Well, all right. Let's go through the question and then we'll see what prize you choose. Anybody else have bingo yet?
It's really bad. Quote, 5 is wrong.
Oh yeah, my bad. Sorry about that. Overly eager on that second question. Rule 23. Judge can arrest if facts do not constitute public offense, or if they find the judge finds the defendant is mentally ill and it's obvious, and for good cause. All right. It's kind of a scary rule to me that the judge can arrest. So it kind of takes our discretion away. They can act on their own. Anything to add to this one?
We just did state's appeal in this rule where Judge Corus granted a motion to arrest judgment. It was also a motion to arrest trial. So the two are different. And what I find weird about Rule 23 is arrest of judgment is usually the traditional one. You can arrest, or you can arrest it if there's not sufficient evidence to support. I mean, that's really what this is, the sufficiency of the evidence. And if he does that, it basically kind of operates as an acquittal, not exactly. We can appeal that if he does that, but if he gets affirmed, the defendant's off. I mean, basically we're done. You can't retry him on that thing. But what I find weird is one of the defendant is mentally ill because you can't convict a mentally ill defendant, and so I'm not sure that means. I think that's archaic under our current law, and maybe we need to get rid of it. But then it's the good cause, and you're thinking, well, what's that for? Right? And a lot of defendants will file both a 23 and a 24, which is a new trial, and so
motion for new trial under 24.
Yeah, and so they mush them together, and we're taking a position that good cause must be something different from what you get a new trial for. So.
More egregious conduct, perhaps, or
no, it's just different. A new trial is stuff like, evidence popped up that I didn't know about before, or there was some real big error in the trial that's really clear now, and rather than do an appeal, why don't we just go up on a new trial, just redo the trial or whatever. It's not, it seems to me, Rule 23 really ought to just be about sufficiency of the evidence.
Well, and for the Pharisees in the audience, the question is good cause the same as the equivalent of insufficient evidence beyond a reasonable doubt? I mean, is that what we're describing? Is that quantum that's just enough so that the prosecution does not need its burden of proof beyond a reasonable doubt? I've never heard it equated that way, but it almost would have to be. Good cause can't be cause. I think that's good enough. It's got to be some standard, but I've never seen it.
What's the standard? What's the reviewing standard for the judge? So when the Court of Appeals looks at that, when you appeal it, what are they applying the standard to? Like, Use of discretion, like really low, so the judge has great latitude, or what do we?
You know, they do get some discretion because the trial judge is there looking at the facts, and so there is some of that. The best case we have in Utah on this is probably State versus Workman, and that's one where they affirmed an arrest of judgment because there wasn't enough evidence. In the case that we've appealed, the problem is he called it, he arrested judgment, but it was really based on sort of a claim of not disclosing all the evidence by the prosecution, and then there's this witness that should have testified. And what we've said is, no, you can give the defense a new trial on that, but you can't basically dismiss the case. Yeah, say there's insufficient evidence based on new evidence, right? The judge doesn't get to reweigh evidence the jury never heard. So in some ways, a Rule 23 is sort of like a judge looking at the evidence much like an appellate court was. So if you don't do it, arrest of judgment, and the defendant appeals and says the evidence was insufficient, and the appellate court looks at the record and says you're right, it was insufficient.
But wouldn't a directed verdict play into that as well? I mean, usually defense counsel asks for a directed verdict.
Yes, and in fact,
case, which they didn't rule. No, the state did have sufficient evidence. Let's proceed.
Right, and in fact, that was one of the points we kept hammering down, because in this case, the judge did deny the directed verdict motion.
Right,
and he said, how can he
really it's a motion to dismiss. I mean, the judge can't enter a motion. I mean, the motion for directed verdict is really more of a civil remedy. I mean that.
Well, yes, but you can grant it, and you can take it away from the jury under our rules. And if the judge does that, we're out. We can't appeal it. It's an acquittal.
Scott?
Wasn't, Laura, part of the problem here that the court entertained both motions, even though I think 24 requires that the new trial be filed within 10 days after the imposition of sentence?
Well, no, the rule's been changed. You can file a new trial before imposition of sentence.
Oh, you can?
You can now, because too many people are getting caught up. But that is a problem. But my point is defense attorneys do this all the time. And nobody, including the prosecutors, say, wait a minute, there's a difference between these two rules. And the judge, I mean, they just sort of treat it as all of a piece. So that's part of the problem.
Are we going to talk about that rule, the rule that says these rules don't apply to defense attorneys? Because that hasn't come up yet.
Well, no, it's Rule 41.
Oh, okay.
And it's unpublished.
Only the AG has access.
Yeah, it's an unpublished rule.
I mean, like I mentioned, these rules, the rules that provide remedies are only available to defendants almost exclusively. And the ones that provide sanctions usually only apply to the state. So.
All right, so we had a bingo sometime back.
That's an easy one, scraper.
Yeah, see?
Shut out the crowd from Louisiana.
The winter's coming.
Thank you.
Hopefully sooner than later.
Whoa!
No.
No. You can't ride a Harley in 2 feet of snow.
No, but there are other things you can do in 2 feet of snow. All right.
So you can't roller skate in Buffalo.
After appeals. A little vague here.
Oh, it's
Anyone?
Disposition after review?
I don't know.
Post 28 and Rule 64D.
So we got a 64D. Put that on your bingo sheet, you're screwed. 28?
28.
You can't be 64 because that's the...
He said it's a civil.
And this is the rule that just tells everybody what happens after appeal's been decided and the case is returned to the trial court with a remittitor. It's supposed to be done timely, but the fourth district, it's when they get around to it.
All right. Everybody clear on Rule 28? All right. When you're looking to start a criminal prosecution, what rule tells you how to start? Rule 5. We go 5 now. All right. All right.
You were too late.
Since there's 2 people at the same table, you're going to have to share.
Is this the variant, John?
Yes.
Well.
Any guess which one was the most expensive prize out of the 5-hour scraper and an Oreo.
Oreos.
5 hours.
Oreos.
Yeah, mega stuff.
The Oreos will be available after this for anybody that, so
After the presentation.
come get them.
Prosecutor authorization for filing of information shall not apply in cases where magistrate has reasonable cause to believe the person to be charged may avoid apprehension or escape before approval can be obtained. So that's kind of the exception. The rule, obviously, is that every information requires prosecutorial authorization. And I've been thinking, I've been trying to contemplate this, like, is this saying that the judge has carte blanche to file an information or to indict, which obviously we don't, but what is this? What is the purpose of this exception? And I think that certainly I should be corrected, but I think it's where if we file the information and it has something wrong with the information, maybe it hasn't been signed or something like that, and it needs to be cured, but the judge reads what the charges are and realizes that, well, we should probably file this information because the person may escape or avoid apprehension. I think that's what it's allowing the judge to do. Frankly, I don't know what other purpose there would be to allow the judiciary to do an executive function. So I brought it up. Maybe somebody had an idea on it. It's in the rules, so it's true. Right? You haven't seen this one yet, huh? All right, somebody exercise this one and see what happens. No? All right, go 5. Oh, no more prizes either, so just so you know, we're moving forward with no prizes.
Play a lot of prize.
I know everybody's out, right? Almost time. Almost time. Arrest and summons.
6.
6? We have a 6. Rule 6.
Okay, so you can either have a warrant of arrest, that means you can go pick somebody up, or you can allow a defendant to appear by summons. There's not a public safety implication or an escape implication. The warrant's executed by a PO, the PO, and summons can be executed by anyone who's authorized to serve process in civil action. Okay, that's all.
And if you're proceeding by or asking for a bail amount on your warrant, make sure you articulate the factors from statute. Likely to plead, danger, was awaiting trial, currently on parole. Those factors are important to you requesting bail above the bail schedule, which is what we talked about in the earlier rule.
This would also beg your question, if a warrant may only be executed by the PO, does Utah then not recognize citizen arrests? Just a question to ponder.
At least by rule.
At least by rule.
I mean, I don't know.
There may be common law authority, but that's the rule only says it can be done by a PO.
Yeah. I guess there's also have to Right. What rule explains how to compute time?
4.
The share rule.
Rule 2.
Read the rule, judge had to compute time, including weekends and holidays. And of course, the time requirements can be altered by the court of different cause. This is kind of the reminder that I used to hear from Magistrate Judge Boyce in federal court when I would argue the benefit of a rule, and he would say, Mr. Barlow, they're for my benefit, not for your arguments. Please continue. Don't tell me what I'm supposed to do. But not in a nice way.
This wasn't endearing.
Not so much.
All right, any questions on this one, computing time? And then subject to the civil rules as well. Minute entry.
Oh, that's
32.
32? All right, well, I have no idea, so let's try it. Yes, 32, minute entry.
These are the things that the clerk does to keep track of what's going on in the case.
Okay. What rule states the court may instruct the jury on the law during the course of the trial if doing so will help the jury understand what's going on? Rule 19. So this is another point on that. But reading the jurors matters of law to me is always.
You know, I've only tried one case where this happened. It was done by Judge McKiff, and it was in a two-week case in Richfield. It involved the death of a teenager in a wilderness camp. And Judge McKiff staggered the instructions throughout the course of the trial, and I actually thought that it was enormously effective. Those of you who ever tried cases before the former Judge Dennis Frederick, who would read all of the instructions, pre-trial instructions in a monotone at work 18. No jury understood a single thing he was saying, and he didn't care. And you kind of read the jury instructions for deliberation the same way. This was much more measured, and it really was, I thought, very effective. But it's the only time I've ever seen it done, even though the rule authorizes.
So do you think if a matter of law is read to the jurors, that it then needs to be formalized in an instruction? Or can they be different? I mean, as a best practice, it should probably be made into an instruction.
I would think so. It's about the law. I mean, you would think that all the instructions would be in there. All I can say is just make sure all the written stuff has all the stuff they really need to do.
Okay.
Because there are a lot of curative instructions.
Well, but the court clearly rules on matters of law and is functionally instructing the jury every time the court rules on an objection or rules on a motion to strike. And those are not submitted; those are not reduced to writing. But so there are rulings on law which happen during the course of the trial, of course. But these are the more formal ones. So there is some difference, but don't.
Yeah, I guess I was thinking of something that they instruct them on. It's not, it's not every form of a jury instruction.
Well, and for instance, you may have things like, and this has happened to be, there may be an objection to an attorney commenting on the evidence. I made that objection, it's been sustained, and then I've asked the court to instruct the jury what actually is going on there. I don't want them kind of speculating, nor did I want them to assume I was just being a jerk. But there was a reason that counsel are not allowed to comment on answers, like, well, that's just what I needed, or that was very helpful, or, well, that was, that's what I was driving at, or something like that.
Really?
Or, yes. Or the more common, which is still a comment on the evidence, okay. None of you is old enough. I did that in, I think, my third jury trial before Judge Jay Banks. And about the third time I said it, he yelled at me in front of the jury, "Stop doing that! You're commenting on the evidence!" I peed my pants, and then I finished the trial. But I don't say okay after questions. So.
All right. Well, and so the objections to any jury instruction must be made prior to being read to the jurors. So just make sure you remember that the court hasn't asked if there's any objections to the instructions before being read, that you stick to that.
Correct. And here's a nice trick, a nice tip, I should say.
No tricks.
Because on appeal, the issue is going to be because the defendant objected to something, not us. So if you can make sure that it's on the record that the judge asks, are there any objections or any more objections, and gets both parties to say, no, I'm fine, Your Honor, those are just fine. Actually, the effect of that, it becomes invited error, and the defense cannot argue plain error or anything about it on appeal. They'll have to argue their counsel's ineffective if they want to get anywhere with it. So it's really good if you can get that on the record. And one way to do that, if your judge isn't done, say, Your Honor, just one thing about the jury instructions I just want to put on the record. The state doesn't have any objections to any of these instructions, and I'd like to make sure that the defense doesn't either, so we can make sure we have everything taken care of in case of an appeal.
Yeah.
You know, right? So
well, I mean, you put the whole trial on, and you forget to have this on the record, and I mean, they go after jury instructions all the time.
Yeah. But that is a nice thing we've got procedurally on appeal, that you can do that simple thing, and sort of it helps bulletproof your
So thank you. Excellent practice and rule. All right, what rule puts fine and fee payments from a DUI conviction in justice court on hold until the resolution of the appeal? Whoa. All right, so those of you doing DUIs can't impose anything. All right, what rule states qualifications for the defense counsel on
Rule 8. Bingo. So this is, well, good for you.
Rule 8 qualified.
You now have the approval of your peers. Rule 8
your fourth best?
lists qualifications for counsel in capital cases. And there's the number of, you have to have done a certain number of felonies and a certain number of murder cases. And this is to obviate claims of ineffective assistance of counsel, which were common back in the day. I remember working on the murder involving 3 defendants, Codiana, Marvell, and Dunstan, back in the late 70s. One of the defense counsel, O.J. Sweetring, now deceased, slept through most of the trial. He was an elderly gentleman in his 80s, and he just couldn't quite keep up. He hadn't tried a case, except as a justice court judge, for about 25 years. So this gets rid of those problems.
And there's no qualification requirement for prosecutors, although best practice, obviously.
Correct. They don't really care.
They prefer to have somebody that's qualified. All right, bingo question. In a stay of sentence pending appeal, this rule states the court may at any time, for good cause shown, amend the order granting release to impose additional or different conditions of release.
27.
Wow. Great, 3 in a row. Before a defendant can be released from custody after filing a notice of appeal, the court must issue certification of probable cause, and by clear and convincing evidence, the defendant is not likely to flee and does not pose a danger to the safety of any other person or community. All right? Now, we kind of think that once the notice of appeal or the appeal process is ongoing and that we've lost jurisdiction, if there's a reason why this person needs to go back to jail during the pendency of the appeal, this rule allows you to go back to the lower court and have the order amended. It's good to know. So don't forget about the person. Have your agent continue to monitor. Maybe check in with the victim, make sure the defendant's behaving.
And there's a statute that goes with this. The standard in the statute is what counts more.
John?
Oh, okay.
I was just going to make the same comment.
Okay.
So,
Although I think the rules maybe been amended to maybe conform more to it.
and what do you know?
It's
Is it victim's rights?
no, it's
Something like 77, 2010.
yeah.
I
I
want to
think
say.
that's 177 2010.
And there's a Utah Supreme Court case from the 80s saying that if there's any conflicts between the rule and the statute, that the statute controls.
Yeah.
All right, so the thing to walk away with on Rule 27 is the Rule 27 does not govern. All right.
Very much.
Very much.
It governs the procedure,
Sort of.
not the standard.
There you go. All right. Note to self on Rule 27. Okay, what rule states a subpoena may compel the attendance of a witness from anywhere in the state?
14.
And yes, that's how it works.
All right. You want to do a couple of questions? Or?
Yeah, we've got 3 minutes. Let's do a couple more and see where we're going.
We haven't repeated this. Discovery. Anyone know this one?
16.
Your fifth best. Discovery.
And again, for prosecutors, this means you give over, everything except your personal notes and sometimes those. The defense is required by statute to provide for alibi or insanity, except when they forget to, or when they claim that their alibi defense is really just a defense. And the discovery is what the alibi is, where who was the person providing the alibi, so you can actually check. Unfortunately, the remedy when the state doesn't provide discovery, of course, is sanctions and possible dismissal. The remedy for when the defense doesn't is you just get to continue the case, another 60 or 90 or 120 days.
Or just give us 5 minutes to review it before.
Yes, or you just have to go without the kind of preparation.
Shouldn't the remedy be that it doesn't come, technically, on the rule book?
The only time that failure to comply with the rule by the defense results in the evidence not being allowed or the procedure not being authorized if it's done purposely and in bad faith with the express purpose to cause delay or frustration of the administration of justice, which is something that most judges are loath
Never going to happen.
to do. I do know, again, in the old days, I remember a defendant coming in with late notice of an expert witness, like 3 or 4 days before trial. And again, the remedy for the state is you don't get to put your expert on. The remedy for the defense is, well, you want a continuance. However, in this case, the delay, even though I did not argue that it was purposeful, again, Judge Frederick said, that's fine, I'll grant a continuance. Bobby put Mr. Defendant in cuffs, and he'll be in jail until we have the trial. And when I got back to my office, the defense attorney called and said they would accept my plea offer. That doesn't work so much.
Yeah, I think what's important about this as well is that you really need to have the court not only file the motion for an order, but that the order gets signed. If the judge doesn't sign the order and you're in trial and it hasn't been provided and it's not required by statute, you really don't have much leg to stand on to enforce the sanction or the penalty against the attorney, which in turn is against the defendant. So always have that order signed before trial, and if you want to review the evidence, have it signed at least by final pretrial, so you have a couple days to do so. Also, I want to bring up, because we have task force, we have agencies, we have law enforcement officers. This is an ongoing obligation that you provide discovery. When the case law is clear, the closer the relationship is between the prosecutor and law enforcement, the greater your obligation is to disclose and discover stuff in the possession of law enforcement. So if you're working closely together as the embedded prosecutor along with what we do, you as prosecutors, your obligation is increased. Increased more so than if you're at the DA's office and you have an officer in Sandy or one of the outlying agencies that are working autonomously. So just be aware of that, and it's ongoing. So somehow set up that protection for you if you're setting the matter for trial or entering a plea, because if you don't discover the person enters a plea and they didn't have all the evidence, guess what?
Yeah, actually, even if they're working autonomously, if they're working on your case, you have a constitutional obligation to disclose that, and if you don't, and it's material, it will get reversed.
Yeah.
And if it's not reversed or appealed, it will get reversed potentially decades later.
It's the Supreme Court.
Yeah. No, I know.
Factual innocence.
It's not factual innocence. It doesn't even have rights.
Right.
All right. So very important. It's your obligation on discovery, even if it's not in your file or in your office. So that's a training aspect with your law enforcement officers every time you have a plea or a trial. Any questions on that?
And thus ends the session. You can read all the rest of it this evening when you relax.
There's already a back here.